Thank you, Mr President. I rise on behalf of the Greens to indicate our cautious support for the second reading of this bill and note that we also have many questions that we would like answered before offering full support. The desire and need to diversify an industry or business is certainly understandable, and we must acknowledge the significance of aquaculture in our state. Certainly the new and emerging opportunity for tourism as part of the aquaculture industry is exciting. And indeed, I've seen fishery businesses going down this path during the pandemic, and good luck to them moving from fishing to tourism. My understanding is, however, that there's already 2 developments that might fall under this bill, and that there has been some interest from the industry in further aquaculture tourism developments. I understand from the tuna industry relating to tuna rings off Port Lincoln, and that there has also been some interest on Kangaroo Island as well, Mr Acting President. While we appreciate the desire for progress and innovation in tourism and the need for businesses to be able to diversify, we do wish to ensure that with this legislation that is done in the best way for all involved, and indeed we have some concerns that have been raised in the other place and that we will echo here. We continue to be unclear in this bill whether the environmental protections that will be in place as part of the new planning approval process envisaged under this legislation will be as strong and as stringent as they should be. Indeed, we want to ensure that the EPA standards do remain strong and stringent, and it is unclear to us whether this bill, and certainly we don't wish to take the ministers or the minister's staff words in a briefing for it. We wish to have this on the public record. And so I will have questions at the committee stage, but also questions in the second reading that we hope the government will respond to before progressing to a second read vote. We will support this bill, of course, at the second reading stage, but reserve our position regarding that third reading after we go through the committee stage. The questions that we have in the initial tranche are why is this particular type of development being pulled out of the recently reformed planning system legislation? Will similar arguments be made for other types of developments that have been made for this to be pulled out of that planning regime? And will that therefore create a pathway for other types of developments to circumvent the standard planning applications and approval processes and environmental assessments? Further, during the briefing, the minister indicated that there hadn't been oppositional concerns raised regarding this bill. However, during debate in the other place, it was raised that environmental stakeholders and NGOs weren't consulted. So could we please have a list of those environmental stakeholders and NGOs that were consulted, and also whether or not they raised any concerns, whether they indicated support, and in what form that support was indicated. In fact, to the best of my understanding, the consultation was limited to the Department for Environment and Water, the EPA and the Department for Infrastructure and Transport, as well as the AG's department. If the minister could provide clarity as to whether that is the case or whether further consultation was undertaken or has since been undertaken, and whether the lower house concerns that were raised have been addressed. During our briefing, the minister indicated that there were some existing developments that might need retrospective approval under this bill, as they may not have gone through and gotten all the approvals, as they may not have known that they needed to. Is this correct? And does the government think that introducing new legislation with unclear environmental protection requirements is good practice for dealing with developments that didn't get the correct approvals under the current system? The development in question, I believe, is the Saltwater Pavilion from Coffin Bay Oysters and the SA Premium Oyster Farm Tours from Smoky Bay Oysters. Now, I have named them, but I would like the minister to address whether or not this legislation has been drafted with those particular businesses in mind. Further, Mr Acting President, the minister has stated, and I quote, if a proposed tourism building work application is to overlap any portion of an existing aquaculture lease or corresponding licence within an aquaculture zone, any associated tourism authorities may only be granted with the consent of these entities and any registered specified persons who hold an interest in them. Could the minister please outline how this process will be managed, as it is not clear in the bill? Throughout the bill and the minister's contribution and briefing, there have been several references to aquaculture tourism developments needing to be ecologically sustainable. How does the government define the criteria for ecological sustainability in this context? How will it be measured and how will it be enforced? During the briefing that my office received, the Minister indicated that while aquaculture sites already need to provide annual reports, this reporting will likely cover the activities and impacts of structures and activities undertaken as part of the aquaculture tourism development, though flagged that this will probably be less extensive than existing reporting and might not cover things such as waste. Would reporting and measuring waste, for example, associated with a development not be necessary to measure its environmental impact and ongoing ecological sustainability? If the Minister could provide clarity on that, that would go some way to addressing the Greens' concerns with this bill. Further, during the briefing, the Minister indicated that this bill is not limited to developments that are demountables, but that infrastructure has to be able to be removed. I do know that this seems to be different to the advice that the Labor Party received in their briefing, and as was alluded to in the other place, where they state that the Minister informed them that these structures must be demountables. So will the structures all be demountables? And if not, what kind of infrastructure does the government then consider will fit this criteria within this legislation? Further, Mr Acting President, when my finger can turn the page over. Given the government has acknowledged general limitations of the Aquaculture Act in their second reading speeches in both houses, why are they not waiting for the broader review of the Act so that this can be properly consulted on and implemented? Why is there a rush for this legislation? What relies on this this piece of legislation passing within this current sitting period? And finally, during the debate on the bill in the other place, the Minister indicated that it is a requirement that aquaculture tourism development authorisation be granted that the development benefits or value adds to the existing aquaculture operation. But the bill is quite broader than this. It states that the Minister must be satisfied that the relevant building work and commercial tourism activity comprising the development will, and I quote, will complement, promote, be of benefit to or otherwise relate directly to aquaculture undertaken within the aquaculture zone, end quote. I think many would agree that that's quite broad, and many things could, quote, otherwise relate directly to, end quote, aquaculture undertaken within the aquaculture zone. What does the government envision these projects that, quote, otherwise relate directly, end quote, to aquaculture undertaken within the aquaculture zone might entail if they don't already, quote, complement, promote or be of benefit to, end quote, that same aquaculture undertaken within the aquaculture zone? As I say, we have some concerns regarding this bill. We are gravely concerned with respect to the lack of consultation with NGOs and particularly the environmental stakeholders, and we look forward to our answers assuaging those fears, or indeed, should they not, that this bill perhaps be given more forethought and consultation and be brought back in the new parliament.